My name is Michael Young, and I'm a lawyer who handles life insurance beneficiary disputes. I want to discuss a case out of the federal court in Ohio that I find interesting. And the reason I find it interesting is because the federal judge overturned several ERISA beneficiary designations because the judge found that the insured had lacked mental capacity to execute two of the designations, and also that the designations were the product of undue influence. Those claims, particularly undue influence claims, are not easy to prove. So this case is particularly interesting because the federal judge found that they had been proven. The situation was that an insured was a longtime employee of General Motors. And through General Motors, he had life insurance, which was an ERISA plan because he obtained it through his employer, and the administrator was the life insurance company MetLife. And so he had designated, he executed a beneficiary designation way back in the 80s. But then in 2009 and twice in 2011, he had executed new beneficiary designations. And what the court did in a detailed opinion was to essentially invalidate those three later designations, the two in 2011 and the designation in 2009. And there was a complicated fact scenario, which there usually is in these cases. But the bottom line was it was a dispute between siblings as to who ought to receive the policy proceeds. And the court examined detailed testimony and found that this gentleman was lacking mental capacity to execute the later designations. He had become forgetful. He was unable to pay his bills. He needed substantial assistance in his life activity, according to all of the children, frankly, and the doctors who had examined him. He had become a hoarder. He had developed a bed bug infestation. His physical appearance had begun to deteriorate. He was unkempt. All signs of someone struggling with capacity. As far as undue influence, the court found that one of the daughters, the one who was the beneficiary of the later designations, had attempted to restrict his contact with other members of the family. His phone had been cut off, and there was testimony that she had not paid the phone bill, so he could not talk to other family members. And isolation is a key component that I see of undue influence claims. Someone isolates the testator or the policy owner from other people, and that makes it easier to influence them or to work some fraud on them to get them to execute a beneficiary designation, particularly if other people don't know about it. As part of its analysis, the court also noted that with ERISA, the ERISA administrator, in this case MetLife, is obligated to follow the plan documents. And of course, the plan documents inevitably say they're supposed to pay the designated beneficiary. But the court said that analysis was not enough in a case like this because those plan documents, in this case the beneficiary designation, parties have called it into question because of allegations of capacity or undue influence. And those kind of fact-specific allegations, MetLife and the typical ERISA administrator, they really don't have the ability to judge whether or not somebody's been the victim of undue influence or whether they lack capacity. And that's typically the case, and why they will file the interpleader in federal court and let a court decide whether or not the beneficiary designations are valid. Anyway, I think this was an interesting case. I handle a lot of disputes, many involving ERISA policies, in which someone claims that a designation is no good because of lack of capacity or undue influence. And while those are viable claims, they're difficult claims. So it's interesting to see a federal judge in Ohio invalidate designations on both of those bases.